Hello and welcome to Rights and Recourse, a program that tackles constitutional, human rights and legal issues, bringing you information and analysis. My name is Dumila Mateza. Remember, you can also be part of our discussion today by calling us on 011 714 5497 or 5498, or tweet us at Rights Recourse. Alternatively, you can email your thoughts to rightsandrecourse@sabc.co.za. During the Nkandla judgment, Chief Justice Mogoeng Mogoeng said an obligation is expressly imposed on the President to uphold and respect the Constitution, that is, above all other laws in the Republic. As head of the National Executive, the President is uniquely positioned, empowered and resourced to do much more than what other public office bearers can do. It is no doubt for this reason that Section 83B of the Constitution singles him out to uphold, defend and respect the Constitution. He also went on to say, this imposition of an obligation specifically on the President still raises the question, which obligations specifically imposed by the Constitution on the President has he violated? Put differently, how did he fail to uphold, defend and respect the supreme law of the land? In the judgment of Friday, December 29, 2017, the Constitutional Court directed Parliament to establish rules for the impeachment of the President. But let's first take a look at this insert.
An order will thus be made that the President's failure to comply with the remedial action taken against him by the public protector is inconsistent with his obligations to uphold, defend and respect the Constitution as the supreme law of the Republic, to comply with the remedial action taken by the public protector, and the duty to assist and protect the office of the public protector so as to ensure its independence, impartiality, dignity and effectiveness. Similarly, the failure by the National Assembly to hold the President accountable by ensuring that he complies with the remedial action taken against him is inconsistent with its obligations to scrutinize and oversee executive action and to maintain oversight of the exercise of executive powers by the President, and in particular, to give urgent attention to or intervene by facilitating his compliance.
To discuss today's topic, we are joined in the studio by Mr. Mfesane Siboto, lecturer at the Wits University School of Law, and from our Cape Town studio by Ms. Pepelapi Dube, Director for the Center for Constitutional Rights. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse.
Thank you so much.
The question I want to ask, probably both of you can hear, is I've always asked the question whether Parliament appreciate the fact that we are a constitutional democracy, or is this an irritation to some? In a paper by President Thabo Mbeki, he writes and say, and I quote, "The Constitutional Court made an outstanding contribution to the clarification of the issue. What do we mean when we say ours is a constitutional democracy?"
Okay, what we mean by that is that there's been a shift from how the country was governed pre-democracy. What we now have is a constitution, which is the supreme law of the land, which governs all conduct of the executive, the judiciary, as well as the legislative branches of government. And all their conduct in all instances must be consistent with the Constitution. So basically, that's the nub of what we mean by constitutional democracy.
Ms. Dube?
Indeed, but just to add on to that, and I think perhaps what we've largely been witnessing is perhaps this tension between, the fact that we are a constitutional democracy, and on the other hand, we have a group of unelected judges who sit at the highest court in the land, who essentially have the power and the ability to strike down any law or conduct which is inconsistent with the Constitution. So I think that's really one of the reasons that we keep having this question over and over again of what exactly does it mean to have a constitutional democracy if we can have judges sitting in court telling elected officials what to do and how exactly their power should be exercised. But of course, we also need to be mindful of, the nuances that come with what exactly it means to be a constitutional democracy. And of course, those kinds of nuances give rise to debates about, judicial overreach versus the very notion of separation of powers. But of course, as we already know, we are a constitutional democracy, and any law or conduct which is inconsistent with the Constitution is automatically invalid.
If one were to, Vesana, if one were to put these two arms of the state in a hierarchical order, the executive part, the National Assembly, and the judiciary, which one would go first? Because if you say that the judiciary are the interpreters of the Constitution, which one goes from? How would you list them? Or are they not supposed to be listed that way?
I would phrase the question differently, because strictly speaking, there is no hierarchy. It's a question of functions of each branch of government. What you have is the parliament, which by and large enacts laws, and then you have the executive, which carries out those laws. To an extent, there's a challenge on the conduct of either of these parties is for the judiciary to then interpret and make a finding. And this now links up to what Ms. Dube was saying in Cape Town. I don't know whether telling Parliament by the judiciary is the right phrasing, because that presupposes that there is external power that the judiciary has which exercises outside of the Constitution, when in fact what is happening is an interpretation of the Constitution. I would rather phrase it differently and say the judiciary interprets the laws and directs Parliament on how to act on the basis of the Constitution, not the whims of the judiciary, but on the basis of the Constitution and the applicable laws. So as far as hierarchy is concerned, I would shy away from that wording, in as much as I would shy away from saying Parliament is told by the courts. What happens is there's interpretation of the laws, which then the legislature and the executive are directed to comply with.
Mr. Dube, I don't know whether I'm right. Correct me if I'm wrong. This judgment of the 29th of December, is it not an interpretation of Section 167 4E, that which says that only the Constitutional Court can decide whether Parliament or the President has failed to fulfill its constitutional obligations?
Well, I think that's more or less simple enough. But of course, judging by the fact that we had 4 decisions that came out of the court on that particular day, on that particular issue, it probably isn't an issue which is straightforward enough. But yes, it is very much one of those instances where the Constitutional Court found itself having to weigh in on a matter in which the Constitution does give, over a matter in which the Constitution has given the Constitutional Court competence over. So, of course, in that particular instance, as you mentioned in your introduction, the question really was the extent to which the National Assembly understood its functions in terms of its oversight function over the executive, as well its constitutional obligation to scrutinize the actions of the executive. And of course, that includes the actions of the president as the head of the executive. So yes, in a nutshell, that was very much the question that was before the Constitutional Court.
We've always said, Vasana, this issue of majoritarianism, where the ANC, which has more people in parliament than any of the other parties, by virtue of it being the ruling party, and also in the committees, they have more members in those committees. Many people are saying the ANC is frustrating Parliament in meeting its constitutional obligation by using its numbers.
In my mind, there's no doubt about that. There's no debate around that issue. And I base my opinion solely on what has come out of Luthuli House. Consistently, we've had that members of Parliament owe their duties to the party. There is no concept of conscious of free will, as it were. this is in direct violation and contrast of the imperatives of the Constitution, which says once you take an oath of office as an MP, you owe obligations to the Constitution itself. So there's no doubt in my mind, I mean, I could go on through a myriad of examples to this effect, but the number of the case is exactly what you're saying, that ANC is using politics in Parliament to frustrate the obligations of the Constitution, amongst others obviously being the issue of Nkandla and the state capture report.
Ms. Dube, do you want to weigh in on that one?
Yes, certainly. But I think we also need to consider certain constitutional provisions. So, for example, or rather an example that I'm going to focus on in this instance is Section 47(3)(c) of the Constitution, which basically makes party political membership a prerequisite to one remaining a member of the National Assembly. So that on its own means that members of Parliament are first of all beholden to their party bosses before they're beholden to the Constitution itself. But of course, as the secret ballot judgment did remind all of us, and indeed did remind members of the National Assembly, it just basically said that their first duty is to the Constitution, and in that sense, they are very much they very much have to work to advance the aims of the National Assembly. The aims of the National Assembly insofar as, you know, the Constitution describes what the National Assembly is supposed to be doing. So in a sense, with this impeachment ruling, it's just basically the Constitutional Court trying to remind members of the National Assembly that even if they represent political parties, but once they are within the halls of the National Assembly, it's important to ensure that their values are really about advancing the work of the National Assembly. So if the National Assembly is tasked in terms of the Constitution, tasked with holding the executive accountable, it really shouldn't matter that, you know, the head of the executive happens to come from the same political party. The only question before that member of Parliament should be, how am I advancing the work of the National Assembly? So I think in that case, the Constitutional Court did try and lend further understanding and lend perhaps greater interpretation to the roles of the members of the National Assembly within a constitutional framework, notwithstanding the provisions of Section 47(3)(c).
Let's take this call from Lehlonolo from Johannesburg. Lehlonolo, good afternoon and welcome to Rights and Recourse.
Mr. Matez, how are you?
Well, thanks, how are you?
Good, man. I think mine is just a question to say, what do we as South Africans, or rather voters, do in a situation where we find ourselves right now, Parliament saying, rather judiciary saying the President has failed to uphold the Constitution, and they're taking it back to Parliament, and Parliament refusing to hold the President accountable. Aren't we supposed, as South Africans or as voters, to have a word there to say where to from now? Because I think it is clear that there's a grey area there. Then it becomes from there to post. Nobody takes responsibilities and whatnot. What do we then as South Africans do?
There you are. That's the question that's on everybody's mind. And Lehlonolo is asking, what do we do? The only time we have a right to show what we can do is when we go for a vote at the end of 5 years.
Well, that is one amongst other strategic pathways I suppose the electorate can use to hold the executive to account. I mean, over and above, obviously, enfranchisement, i.e. the right to vote. But in between that are other mechanisms such as protest, which one would argue has not yielded much result, amongst other pathways. I mean, I suppose the debate that we should have as South Africans, but what we have as it stands is a system in place which provides for when we can hold the President to account, i.e. as the National Assembly, and of course as citizenry in general. But what we currently have as it stands is only Section 89, should you so wish to remove the President. You have 102 for the motion of no confidence, which obviously implicates the cabinet as well. As to how we put those into effect is a political question, and I suppose that's what everyone is trying to get at. And I suppose the suggestion by Lehlonolo is that we've been going back and forth, the challenges and cross-challenges, so they're not really being put into effect. They're not serving the purpose they ought to serve. As to how do we rectify that, I suppose the question Lehlonolo and the rest of South Africans will have to answer.
Well, let me go back to something else, Mr. Dube, that you raised. You raised for Section 47 of the Constitution. Section 48 of the Constitution on the oath or affirmation reads, before members of the National Assembly begin to perform their functions in the Assembly, they must swear or affirm faithfulness to the Republic and obedience to the Constitution. This is not what holds, what's the pillar of being a member of Parliament.
Yes, absolutely. And that's very much the crux of what it means to be a member of Parliament. And I think that's what the secret ballot judgment was at pains to impress upon the different members of Parliament. But I think at the same time, we also need to talk about the role in general of political parties within South Africa's constitutional democracy. And I think we've seen quite a few decisions. Well, at least in 2017, you had the KZN High Court judgment, which basically annulled the KZN Provincial Electoral Council, the KZN PEC. But basically the crux of that judgment just being the fact that it's also important for political parties to have, their own processes, to have their own laws, which are very much aligned to the Constitution, because in a sense, it's really about deepening South Africa's democracy. So those kinds of judgments just made it quite clear that democracy isn't just a notion which only happens within the National Assembly or happens within, the national sphere. It's really a concept that starts with political parties, and it's just important that even at grassroots level, there is an alignment, there is a keen awareness of the role that the Constitution plays.
Well, if you'd like to join us in today's discussion, you can call us on 011 714 5497 or 5498, or tweet us at Recourse. Or you can email your thoughts to rightsandrecourse@sabc.co.za.
So the issue of waves is that don't underestimate yourself. You are exactly the cornerstone of the solutions we are looking for.
To go and intervene and make sure that people respect the Constitution.
Now, if drug dealers are paying political leaders, then you will never get rid of that problem.
We need to see detail that we will not see further bailouts.
Fidel, a towering figure of the 20th century.
Stay tuned to PM News for all your news updates every Saturday and Sunday from 1500 hours.
I wish to emphasize that I never knowingly or deliberately set out to violate the Constitution, which is the supreme law of the Republic. The finding by the court that my failure to comply with the remedial action taken against me by the public protector is inconsistent with the Constitution and therefore invalid, flows from the fact that I initially followed a different approach. While correct in law at the time, the approach was subsequently demonstrated to be contrary to the Constitution.
And we'll go back to comment on what the president was saying there after the Constitutional Court judgment on Nkandla. But let's take this call from Paul in Johannesburg. Paul, good afternoon and welcome to Rights and Recourse.
Hi, how are you?
Well, thanks. How are you?
Great, thank you.
Yes, go ahead, Paul.
So my question is, in terms of the 29th December judgment, do you not think that we have reached a stage where the courts have become an all-powerful branch of the country, and where judicial overreach is actually going to become a problem for us? And how can we actually stop the courts from taking such decisions that affect an entire country, but on the basis of them not being elected? Does that not present a problem as well?
Thank you very much, Paul. That's a very short question, a question that I actually asked when I asked for whether can we put these arms of the state into a hierarchy as which one comes first. Let's go back. We'll go back to what Paul is asking, because I've got a specific question to that regard. But let's go back to what the president is saying in that insert. The president says he was not aware that he was breaking his oath of office when he stalled against the remedial action of the public protector. But there's a saying in law, ignorance of the law is not an excuse.
Yeah. Well, it's not as simple a concept as that. I mean, I take the point. But there are instances where the law will allow you to make the argument. But I don't think it quite holds in the instance of the president. In my mind, it was dancing around the issue, to be quite frank, because it is common cause, certainly within the legal fraternity, that the findings of the public protector are binding. And that is precisely the point the president was dealing with in this instance. So the argument is that at the time was not aware that the findings of the public protector are binding. I mean, would recall the number of instances in the National Assembly where he made the point that they are mere recommendations, and now it will turn out that they were actually binding on the president. I am not convinced by the argument that there's legitimacy in that session by the president, though in principle you certainly can use the ignorance of the law as a defense. Coming to the second point, which I think is what your question is leading to, which is Section 89, where the ignorant violation of the Constitution is a defense for purposes of Section 89. It's a question of interpretation, is it not? Because the Constitution is not explicit as to willingly or intentionally breaks the law. If, as a president, there are steps you could have taken to ascertain and satisfy yourself of the conduct, particularly as important as the question of the state capture report, if there are resources at your disposal, consult widely before you make a decision. Instead of doing that, you take one opinion from one, with respect, sketchy law firm of attorneys, and on that basis make such an important decision. I don't think for me that is enough, certainly for fulfilling, respecting and protecting the Constitution.
Is it as simple as that, Pepelapi, where the Constitution rules that the president has violated his oath of office and disrespected although it didn't say exactly as I say, I'm paraphrasing the Constitution, and just for the president to stand up and apologize?
No, it's certainly not enough, and I'm obviously glad that you clarified the fact that the Constitutional Court did not explicitly state that the president had violated his oath of office, because I think that had the Constitutional Court mentioned that particular phrasing, I think it would have had, an absolutely different legal implication. But anyway, to answer your question, no, it obviously wouldn't have made much of a difference. And I'm sorry, I've lost the signal.
No, go ahead, we can hear you. We can hear you, go ahead. While she's trying to hear us. Oh. I think one of the other issues, the court did say specifically that, because the question I quoted earlier is a question that is asked by the Chief Justice, say, which obligation specifically imposed by the Constitution on the President has he violated? In other words, the court did say the President violated the Constitution, and we normally say in any other democracy that President would have resigned.
Yeah, certainly there's no doubt in my mind that in any other fully functional democratic system, the President would have resigned.
Without being nudged.
Well, see, that is precisely the point. Then it becomes a political issue. I'd rather confine the argument on a legal basis, because certainly it's less murky than politics. But what we're dealing with here is a finding by the court that the president has failed to empower, to defend and to respect the Constitution, i.e. the Public Protector's report. He simply pretended it didn't exist simply because his view was a recommendation. That is a serious indictment on the conduct of the president, over and above, obviously, all the other instances where the president has been found wanting. In my mind, certainly in a functional democracy, a president would have long resigned.
Let me put that question to Pepe Labi. I don't know whether you heard the question. The question was, the Constitution did say, the Constitutional Court did say, because the question is asked by the Chief Justice, this imposition of an obligation specifically on the president still raises the question, which obligation specifically imposed by the Constitution on the president has he violated? Put differently, how did he fail to uphold, defend and respect the supreme law of the land? Therefore, the Constitutional Court did say the president violated the Constitution.
Well, yes, in a question of semantics, it would appear as if the president obviously did violate the Constitution, bearing in mind that the findings of the public protector, and obviously bearing in mind that the public protector's office is an office which is umbilically linked to the Constitution, in that it's specifically mentioned in Chapter 9 of the Constitution, and therefore its findings are umbilically linked to the Constitution. So that on its own means that, the president, in failing to adhere to the remedial recommendations by the president, that obviously was a violation of the Constitution. But also the fact that the president then second-guessed the findings of the public protector, in the sense that the members of the National Assembly went on to establish a subcommittee which then second-guessed the findings of the Public Protector's Office, and in a sense established a parallel process which served to undermine the Public Protector. So that on its own, and perhaps we should speak to the brilliant legal strategy of the EFF, in that is when the EFF then approached the court. And one of the things that they asked the court to declare was that the National Assembly, in having second-guessed the ruling, or in second-guessing the findings of the Public Protector, was in essence also failing to abide by the Constitution, because it meant that that particular committee was failing in its oversight function. So that, in a nutshell, is how the president in that particular instant failed to uphold his constitutional obligations.
But let's take this call from Billy in Kimberley. Billy, good afternoon and welcome to Rights and Recourse.
Good afternoon.
Yes.
Let's get this point clear. Before the case went now to the constitutional law, it went now to the Cape High Court, where now the Cape High Court judge said that now the recommendations of the public protector are not binding. Hence now the president didn't, as a matter of fact, now he took now from the High Court that now the recommendations of the public protector are not binding, getting in from the High Court. Could just get the answer from there. Thank you very much.
Thank you, Billy. What Billy is making reference to there, Mfesane, is the SABC COO versus the public protector, the case that was brought to the Western Cape High Court, who said, was Judge Skipper said, the public protectors are just recommendations, and they cannot be ignored, but they cannot be ignored. Underline that.
No, absolutely. See, that's the thing. One of the misfortunes, unfortunately, with law not being a science is exactly the point that Billy is making reference to, which is precisely why we have the processes of appeals and reviews within the judicial system. Eventually, of course, we go to the Constitutional Court, which set us right as to what the powers of the public protector are. I mean, I take Billy's point, but we're talking about all these resources that are available to the president. It can't reasonably have been that the president relied on a judgment that was commonly understood, certainly within the legal fraternity, to be flawed. On any interpretation of the law, you can see what the problem with that judgment was. So the point we're making is it was not enough for the president to rely on that. It was convenient, certainly, but certainly not reasonable, because within the space, opinions were bound within the space that this is not the correct interpretation. If the president was of the view that that is a judgment and take into account the responses certainly from the academic field as to what that judgment means, it certainly was incumbent on the president to take it a step further before he dismissed the findings of the public protector.
Pepelabi, I don't know whether you want to weigh in on that, but I want to ask you this question. Section 89 of the Constitution regulates the removal from office of a sitting president. Why not impeachment? Why doesn't say clearly the president can be impeached, like, for instance, the American Constitution?
Okay, before I answer that, I'm just going to weigh in on the judgment that was given by Justice Skeepers of the Western Cape High Court. I think the important caveat there was that the findings of the Public Protector's Office may not necessarily be binding if there are some conditions which haven't been met, and of course those conditions pertain to whether if the findings themselves were patently unlawful. But I think in that particular instance, that fact on its own had not yet been established. And I think secondly, I think the beauty of our legal system is that it's a legal system which acknowledges upfront that the magistrates and the judges are ultimately human beings, and that there can be mistakes which are made. So that is why we have an appeal process which goes all the way to the Constitutional Court. So I don't think that we should be attaching much value or indeed giving much adverse meaning into the fact that the Western Cape High Court had a different reading into the powers of the Public Protector, a reading which ultimately differed from that of the Constitutional Court. I think, if anything, it's an important affirmation of our legal system. And then on to your question about why we do not have the particular phrase impeachment in Section 89. I think that really was the point before the Constitutional Court. The fact that Section 89, in this instance, we need to distinguish Section 89, the removal of the president, from Section 102, which talks about motions of no confidence. And that Section 89 is a matter of fact. So it has to be a matter of fact that the president has conducted, that there's been a serious violation of the law or the Constitution, or that there's been some serious misconduct, or that the president is simply unable to perform the functions of the office. Whereas a motion of no confidence is really a matter of opinion. So because it's a matter of opinion, you don't really need to adduce, it doesn't have the same standard. You don't need to adduce the same factual standard as Section 89 demands. And that is why the court found it necessary for there to be a procedure before the actual vote, a procedure which establishes on a balance of probabilities, or perhaps beyond reasonable doubt, if we're going to be adducing factual evidence as to the president's misconduct. So that, in a nutshell, is the Constitutional Court's way of trying to perhaps bring South Africa's jurisprudence in line with other jurisdictions. I think one of the jurisdictions that was very much at the fore, at least during the oral arguments, was that of Brazil, where Brazil has a procedure in terms of which, before the impeachment vote itself, a subcommittee of their parliament meets, and they determine beyond reasonable doubt, and they determine the facts before they then recommend that the debate should commence. And then the members of their parliament will then vote, but their voting is based on this committee having established as a matter of fact that there are grounds for impeachment.
I want to go to something else. You responded to a question in some other television station which I watched, where people were calling for the ANC NEC to recall the president, which was their deployee. And you made an emphatic statement, which I think is fact, that it is only Parliament that can remove the president.
Yes, absolutely. And this is in line with the entire separation of powers doctrine. And I think stripped to its most basic, it's just basically the understanding that the very same people who put the president in that position are also the only people who can remove him from that position. Now, of course, we know that our president is elected by the other members of the National Assembly. So, of course, it stands to reason that it's the same members of the National Assembly who can then remove him from that same office. So, of course, recalling him as a member of the the African National Congress, while it sends a very strong message to the president about the fact that he has lost support within his party. Beyond that, unless and until the members of the National Assembly pass a vote to remove him from his office, beyond that, the decision by the political party wouldn't have the same force, the same legal force that the Constitution demands.
Let's take this call from Peter. Peter, good afternoon and welcome to Rights and Recourse.
Thanks for having me, Baumat. I think that really, let's admit the fact that the Western Cape judge misled the president. Because if we then say that they can make a mistake, their judge, they can make a mistake, then we can say that even the president can make a mistake. I think that even the Chief Justice acknowledged that he was misled. And he gave him the space for that, he was misled by the Western Cape judge to say that, no, remedial actions or recommendations are just mere recommendation by the public protector. And he took it from there until the public protector herself and the EFF took these things to the Constitutional Court. They did mislead him. And we don't know if the Western Cape Judge Court did say that these remedial actions are binding, whether these things would have gone to the Constitutional Court. Let's admit that they made a mistake, a big error. We can't say that they're just human beings.
I don't want to spend a lot of time on this. Thank you, Peter. I don't want to spend a lot of time on this issue of the Western Cape High Court because it is a red herring in this discussion. Because surely you cannot be swayed by what was said in a lower court that in a case that had nothing to do with yours and say, this is what I believed in.
No doubt in my mind. That's just all I've got to say, that there's no doubt in my mind that you've got it on point.
Well, that question is answered by ignorance of the law is not an excuse. The other question I want to come to, probably Pepelani had started talking about it, that is this multi-party subcommittee of Parliament, and there was a suggestion coming from the EFF that if we are to draft rules of impeachment or look at impeachment of a president who has violated his constitutional obligations, why don't we appoint a group of retired judges to look at what needs to be done or interview the person and then come back to us with a report and then present that report to us, and then we study the report and present it to Parliament?
In my mind, it's a good suggestion, and it's a practical as well, because it does away with the politics which usually is the default when it comes to these type of debates. I've suggested earlier on that Section 89, in fact, Ms. Dube has alluded to this as well, that we're dealing with factual questions, quasi-judicial if you like, when we're dealing with Section 89. It presupposes that when you're going to make a finding as to whether the president violated the Constitution, serious misconduct, or is incapable of fulfilling his duties of office, that must be preceded by a factual inquiry. What best mechanism can you have in place than a semi-judicial process to make that establishment? Because absent that, then you have political considerations, opinions, questions of opinions that dictate what the findings should be under Section 89. For that reason, I think it's a good strategy, and it's a good strategy in a sense that what the EFF has done when it went to the Constitutional Court is to understand that by and large, the political parties use their muscle within the National Assembly to reach a decision, not on factual basis, but on politics, requiring that Parliament now have a set of rules where decision will be made by, say, the judges as proposed by the EFF. When you have that system, and they indeed find that there was a violation of the Constitution by the president, on what basis then is the National Assembly do not impeach the president? So it was a good strategy in that sense, but again, it's also good in a sense that it only follows logically that if you're going to make a factual finding, it's got to be preceded by evidence that you're saying. It has to be led by someone who understands the process of evidence that you're saying and eventually come up with a decision.
There is a call on the line, Ms. Dube, but let's probably take this call. I know you're burning to make your voice around that issue. Parky, good afternoon and welcome to Rights and Recourse. Hello, Parky, are you there? Parky, you switch off your television set before you speak to us. Ms. Dube, I don't know whether you want to weigh in on what Mfesana was saying.
Well, I do agree with the premise of what he has said, although I would perhaps express a certain reservation at having judges, even retired judges, being involved in the process, because I think it unnecessarily blurs the lines. I think at the moment, with the nature of a lot of the big cases that have come before the Constitutional Court, there have been cases that have been brought by political parties, and I think it unnecessarily creates the impression that the courts are being politicized one way or the other. So I think, just for the general health of South Africa's constitutional democracy, I'm not too convinced that we need to have judges, even if they're retired judges, being involved in the nitty-gritty aspects of the National Assembly. But obviously, that said, it is important to understand the fact that, if members of parliament are being asked to decide in as a political way as possible, to decide on the future of the possible leader of their own political party, it's very difficult for them to have perhaps a more objective lens. So, of course, it is important to have perhaps people who have the expertise and who would be in a process to guide the members of parliament. But I'm not sure that those people should necessarily be retired judges. I mean, well, regardless of, their expertise in evidence adducing and their familiarity with the legal process, etc. But I just think it's very important to just draw a line between members of parliament as well as the judiciary.
Well, very interesting thought there. Let's go to Parky in Cape Town. Parky, good afternoon and welcome to Rights and Recourse.
Bob Matthias, as always, thank you for taking my call. And to Mfesa and to Pepele, to thank you very much, you guys, for gracing our studio and to actually assisting us, to understand exactly this Section 89, subsection 1, exactly what it is all about. Bob Matthias, many sections have actually been mentioned by our panelists today, from Section 37.3 to Section 102 about motions, the impeachment, and so forth and so forth. But of great interest, it is this Section 89.1. Umfasane earlier on actually touched exactly on what I was wanting to touch when about Matthias, because it is very important for us to understand what these provisions of our constitution mean. The removal of the president. Now there's three ilokunjalapana, A, B, and C. Subsection A, Section 89, subsection A, Section A1, A, B, and C. Those three, what I actually wanted to understand is, could it be necessary that we combine all of those? That is a serious violation of the Constitution or law, B, serious misconduct, or C, inability to perform the functions of the office. As we remember earlier on, Mr. President actually put it very clear that he actually did not intend. He actually acted on the advice given. So let us also unpack that. And until we actually understand what actually the judgment of the Constitutional Court vis-a-vis this of the Western Cape High Court actually say, then we can understand how to interpret on ourselves, but then assisted by the High Court and the Constitutional Court. What exactly does this mean when it says the president can actually be removed on three on three grounds as so mentioned?
Paki, my apologies. You've made that point. You made that point very clearly. Well, we were in the interest of time. We will come back to your question after this break. If you'd like to join us today discussing, you can do like Parky, call us on 011 714 5497 or 5498, tweet us at Rights and Recourse, or email us at rightsandrecourse@sabc.co.za. Stay with us.
live Saturday and Sundays at 8:30 p.m.
Welcome back to Rights and Recourse as we discuss the issues around the decision of the Constitutional Court on December 29 that Parliament set up a committee that will look at whether the President did violate his obligations, his constitutional obligations. The question Paki was asking was a very broad question, which I stand corrected. I think what he wanted to know, should the President, if a President violates only one of those subsections, or all three, there are three of them, yes, all three of those subsections, should that then be regarded as a serious violation of the Constitution?
Well, see, that's the thing. It's quite a convoluted question, but I'm going to answer it on the basis of how you've set the premise. Section 89 provides that the President may be removed on one of three instances, i.e. the violation of the Constitution, serious misconduct, or inability to fulfill functions of the presidency. And remember, the conjunction there is or. What that means is it's one or the other. Now you can appreciate the impossibility, virtual impossibility of removing any president if required all three to be present. And remember, effectual findings, so suppose we've got this commission, this judicial commission, which assesses whether the president has violated either of these three or either of these three factors exist. It still provides that the National Assembly may. So it's permissive rather than instructive. So for that reason, it becomes a political question as well. So does it follow that if it's found that the president has, or rather one of the three factors are present, the president must then go because the wording is permissive in nature rather than instructive to the National Assembly?
I will not be able to get to many of the other questions that I had penned down to ask here today, but I want to go back to something you raised, Ms. Dube, earlier around the fact that Parliament cannot be seen, I think that's what we are trying to say, cannot be seen to be abdicating its responsibility by giving its function to other people. But in my view, with respect to the very assertions made by the Democratic Alliance and the NFP, they made the same, saying that Parliament must not be seen to be abdicating its role of oversight. But if you look at the judgment, Parliament, like the National Assembly, just like the President, was found to have acted unlawfully and in contravention of their own obligations, constitutional obligations. Therefore, to a lay person like myself, Parliament cannot sit and judge over this issue because Parliament itself was found to have been at fault.
Yes, absolutely. But I think the importance of that judgment is that it makes it quite clear that Parliament is, first of all, supposed to be in that position in order to ensure governance by the people. And one of the ways in which it's supposed to ensure governance by the people is the oversight function as well as scrutinizing oversight function, or rather scrutinizing executive action as well as, which obviously includes the manner in which the President conducts himself. So Parliament is ultimately supposed to have the ultimate say. But I think in a sense, this judgment is very much about South Africa's democracy being deepened, because these are the sorts of questions that the Constitutional Court has never had to dealt with before. So prior to 29 December 2017, we really didn't have any clarity on the matter. So of course, I think going forward, it's just important for us to recognize that probably Parliament, the National Assembly itself, was perhaps unaware of the extent to which it could exercise his powers. And I think that's the importance of at least the majority judgment, in that it gives the National Assembly guidance as to how exactly its powers should be exercised. And of course, there's been debate about possible judicial overreach regarding the majority judgment and perhaps Judge Foreman's concurring judgment. But I think the important thing there is that, or the important thing to note is that the judgment doesn't tell the National Assembly what to do. or rather how its job should be done. It simply tells the National Assembly what needs to be done. And what needs to be done is for the National Assembly to establish, as a matter of fact, what it means to have a serious violation of the law or the Constitution, or what it means to be unable to perform those particular functions. And of course, the Constitutional Court has left it up to the National Assembly to determine how exactly the National Assembly is going to arrive at those questions, which are questions of that matter of fact.
Let's take this call from Nkandla from Orange Farm. It's our last caller. Nkandla, good afternoon and welcome to Rights and Recourse. Orange Farm, it's our last caller. Nkandla, good afternoon and welcome to Rights and Recourse.
Yeah,
Can't push your TV, can't push your TV, Nkandla. Switch off your TV.
Yeah, Baba, Orange Farm.
Yes, Nkandla.
Yeah. Mina ngithi le nto ukuthi kufanele ku-remove a president, I don't think it's a good thing. First thing ukuthi so always mase sekusondela ama-election South Africa sizomele si-remove president ngoba kungene i-president. Why singayeki u-president Zuma apart until term yakhe iphele? Because ukuremove yena it's money again esazophuma imali yethu thina bentela ekumele isebenze. And then those people abenza le nto abacabanga ukuthi bathi bona bacabangela thina abacabangela thina because bacabangela bona ukuthi kufanele bangene ekhundleni, which means those people are EFF and DA bagijimela emakhoti.
Thank you very much. We've heard you. We're running out of time quickly, but there's a great deal of constitutional education that still need to be done to a great deal of people, because clearly Mr. Nkandla doesn't understand why this is a topical issue.
I don't know how to respond to his question. I really don't. I'm sorry.
The question, I've got a few questions left. Were you surprised by the dissenting judgments by the Chief Justice and the other judges?
Not at all, actually. In fact, I foresaw before the judgment came out that you certainly won't get unanimity within the judges of the Constitutional Court, certainly not in the same sense we did with the initial Nkandla judgment. There was no doubt in my mind. And it brings to light exactly the issue with this judgment, that it really is a question of interpretation. And because law is not a science, interpretation by definition would necessarily mean you get as many opinions as you get legal minds. So it comes as no surprise to me at all.
Ms. Dube, one of the questions around this very issue that I wanted to find out is how important is a dissenting judgment really in law?
Well, dissenting judgments are quite important, but of course we need to understand that, dissenting judgment isn't part of the order and it doesn't form precedence either. But of course it's just important, just for the record, and also the fact that, a similar issue might come up in Parliament, for example, in the legislative process. And it might be important to look to dissenting judgments in terms of these various points that they make. So from an academic point of view, dissenting judgments are important. And also it just reinforces the fact that judges are ultimately independent and that they arrive at their thought process and their decision-making process in a different manner. And so of course it lends greater credibility for the judgments that come out of the courts in future, because it just sends a message to the public. It lets the public know that the judges are independent people and they don't always arrive at the same decisions, even if they are given the same set of facts, that they think differently, they apply their minds differently. So in a sense it's very much about reinforcing the credibility of the judiciary at the end of the day.
Ms. Pepelabi Dube, Director of the Constitutional Rights, and Ms. Mfesane Simoto, thank you very much for your time. It has been a very enlightening discussion around the Constitution. Justice D.N. Jafta said in the majority judgment, the fact that members of the Assembly assume office through nomination by political parties or to have a limited influence on how they exercise the institutional power of the Assembly, where the interests of the political parties are inconsistent with the Assembly's objectives, members must exercise the Assembly's power for the achievement of the Assembly's objectives. For example, members may not frustrate the realization of ensuring a government by the people if its attainment would harm their political party. If they were to do so, they would be using the institutional power of the Assembly for a purpose other than the one for which the power was conferred. This would be inconsistent with the Constitution. This has been Rights and Recourse. This program is repeated at 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon.
We take an in-depth look of all your stories of the day across the world. Stay tuned to Primetime News every day from 18 hours.